first case to come before us is City of Medina versus Bow Arms. Each side will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. So when you're ready to proceed, we're ready to hear you.
Okay, thank you very much, Your Honor. May I please support Myron Watson representing the appellant in this case, Bow Arms. We raised one assignment of error, but before I get started, I would like to reserve a couple of minutes for
That's
rebuttal.
fine. That's what I was just going to ask you. That's no problem. You go ahead.
We raised one assignment of error, and that assignment of error is whether or not the trial court used its discretion in failing to grant a motion to suppress hearing in this case. The backdrop of this case factually is that Mr. Bow Arms was charged or cited for operating a motor vehicle under the influence, and in that we were challenging the stop of the appellant, as well as contesting the actual test results that were going to be admitted after Mr. Arms was arrested. Mr. Arms, or the appellant in this case, was arraigned on December 1st. Counsel entered his appearance on December 17th because there was already a pre-existing trial date before my appearance, which was January 2nd. Counsel then filed a motion for continuance requesting that there were not complete discovery that was given to the defense at that point, and cited that there were going to be pretrial motions. The court did, in fact, grant a continuance, which is a continuance for a new trial date some weeks later, I believe January 21st. In that scenario, the defendant, or the appellant in this case, filed a second motion for continuance, citing that there were requests for 911 tapes, radio broadcast tapes, along with the video that had not been provided for the defense. Given that factual scenario, we believe that the court did grant a continuance. We requested 30 days. The court, and in turn, only gave us half of that, which required us to have a trial on February 13th. Counsel did, for the appellant, did file a motion to suppress after receiving the videotape, and expeditiously filed a motion to suppress. And I believe that what the state, or Ohio, City of Medina in this case, is challenging is that, well, leave was not granted by the court, and that the motion to suppress was filed outside the confines of the rule. It is our argument that when the City of Medina had filed an objection to our filing to the motion to suppress, that our reply to the court indicating that certain discovery had not been provided, and that precipitated a late filing of the motion to suppress. That was in fact a motion asking for leave to accept the motion to suppress because of the fact that discovery had not been provided. And I think that the court abused its discretion in light of the fact that they should not have allowed the prosecution in this case not to timely provide discovery materials in reference to the filing of a motion to suppress. I think what's important here is that in our motion to suppress, in which the court granted, we indicated that we wanted to file a motion to suppress, and the reason why we were waiting for the motion to suppress to be filed was because the defendant, or the appellant in this case, did not have the videotape or the radio broadcast tapes or the 911 calls that went out over air, which we thought was critical in putting in a motion and making certain averments within that motion that we would have to rely on that discovery. I know that is a high standard in which this court must look at in terms of whether or not the court did abuse its discretion. And I think that the court abused its discretion in this case, but for not having a hearing as to my specific complaint that discovery had not been complied with. And that was not only indicated in the motion to suppress, not in the motion for the continuance, but my response to the state's motion or the city's motion blocking our motion to suppress.
What about the state's contention that your motion to suppress was a standard shotgun-style motion, didn't have any really specifics in it as to what you were waiting to see when you got the discovery materials?
Right. Well, given the circumstances of the motion itself, we were challenging specifically whether or not the trooper had complied with certain prescriptions that would go with regard to giving field sobriety tests. In order to comment on that appropriately and saying that the person had not, or the trooper had not complied with those standards, I would have to have that at tape, and I couldn't make that specific averment unless, or that allegation, unless I had viewed the tape. And I wanted to find out, since there was another aspect to the case, was the radio broadcast tapes, because this particular, the appellant and this particular trooper had in fact stopped Mr. Arms, who was already parked at a gas station. So it wasn't a situation where counsel needed to find that out in order to make a determination of whether or not the officer appropriately stopped the appellant in this case. And I could not just make that determination without having that supporting material. Essentially, that's my argument, unless there are additional questions.
I don't believe so, thank you.
Thank you very much.
Please, the court. My name is Greg Huber. I represent the defendant, or plaintiff appellee in this case, the state of Ohio. The fact in this case, bottom line, is that the defendant received all the discovery from the state of Ohio within time to file a motion to suppress, and if additional time was needed to request more analysis, the defendant would properly file a motion requesting the court extend time within which to file. The rule is that you have to file a motion to suppress within 35 days after arraignment or 7 days prior to trial, whichever is earlier. If defendant's counsel wanted more time, in order to comply with the rule, the appropriate procedure is to file a request extending the time limit. The court is generous in addressing those requests. I would think even this court, when there are time constraints, would require from counsel a request to extend a time complaint. From this side of the aisle, it's not appropriate to accuse the trial court of abuse of discretion when what the trial court did was apply Criminal Rule 12, and what the trial court did was never have a request for an extension of that time period. So essentially, the counsel for the defendant, number one, he got his discovery. Number two, he never filed a request for an extension of time. And number three, he then filed a motion that was out of time. And now we're on appeal because the defendant wants to say that the trial court abused its discretion. And again, that's not appropriate. What was required here was a request for an extension of that time period. It is not a good practice to get outside of the time limits and then expect the court to accept your motion simply because you filed it. There is a requirement that you request an extension if, in fact, these rules are going to have any meaning, or these time limits are going to have any meaning. And from the state side of the aisle, we would respectfully argue that this is not an abuse of discretion.
Thank you, counsel. You still do have 5 minutes remaining.
Okay. Thank you very much. When the city says that the court was judicious in the amount of time that they had given counsel otherwise to prepare and file a motion to suppress, we would contest that finding. We would have to look at the trial court's ruling denying our motion to suppress without a hearing, indicating that the motion to suppress should have been filed on January 5th, which was 35 days after arraignment. The court failed to acknowledge that the very motions that the appellant was requesting was continuances in order to allow the city to provide discovery in this case. And that the motion, in the second motion, indicated that radio broadcast tapes as well as the videotape had not been provided for counsel to ceaselessly file a motion to suppress, given the circumstance that a counsel came involved in the case on December 17, and within 2 months, the case is set for trial. And having a motion filed by February 6, I don't think was unduly prejudiced the city in any way, or otherwise prejudiced their case in any way. I could see if the case lasted for several months with an action of counsel, but the motion to suppress in the case had not lasted more than 2 months. I understand it's a misdemeanor, and I think that the court should at least address counsel's inability to get timely discovery from the city in this case. So for the trial court just to deny it without any questions as whether or not counsel had properly received discovery in this case, and not address our reply to the state's opposition to the filing of our motion to suppress, indicating that we had not received discovery in this case, I think that the court abused its discretion in not addressing. Under Rule 12, the court would have to, in the interest of justice, allow for a belated filing of a motion to suppress, particularly in this case where the city had not provided discovery timely after repeated requests from the appellant in this case in order to receive that discovery, in order to file a motion to suppress. Because our point is that the court in its entry does not make it clear that the appellant's request was, we're seeking this information so that we can file a motion to suppress. And the court didn't say, well, you have 10 days after you receive discovery to file your motion to suppress. So the court just completely disregarded our failure to get the discovery necessary in this case to file a motion to suppress. And we ask that the court vacate the conviction in this case and remand it back to the trial court. Thank you.
Thank you, counsel. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And you can also look on our website where we release our opinions too. Thank you.
Thank you very much.